Hello, I'm Dr. Tanya Wyatt, a professor of criminology at Northumbria University in Newcastle in the United Kingdom. In honor of World Wildlife Day, which this year is Sustaining All Life on Earth, I'll be posting a series of 6 videos to share the findings of my Arts and Humanities Research Council funded project, the implementation of and compliance with the Convention on International Trade in Endangered Species of Wild Fauna and Flora, commonly known as CITES. In this video, I will go over the background of the project, also go into detail about the methods I used over the 2 years, and then give the initial findings from the legislative content analysis, the first stage of the research process. The many environmental crises that planet Earth is facing, one of them is the rate of human-induced species extinction. E.O. Wilson in 2016 estimated this is between 100 to 1,000 times higher than non-human caused extinctions, such as natural disasters. And while the main cause of species extinction and biodiversity loss is habitat loss, could be from deforestation, urbanization, agriculture, the second cause is overexploitation, poaching, and the international illegal wildlife trade. The main instrument for governing wildlife trade is the Convention on International Trade in Endangered Species. CITES is the international legal instrument to combat both the overexploitation of wildlife from the legal trade and the illegal trade. Even though CITES has been adopted by 183 countries, similar to the general difficulties in transposing global commitments into national legislation, implementation of CITES legislation remains inconsistent, compliance at times is lacking, and listed species still face extinction. For instance, in 2011, there were 625 animals listed within Appendix 1 of the CITES, which is the strictest level of protection. There were also 301 plants listed in Appendix 1. In Appendix 2, where more trade is allowed, but it's still monitored through quotas and a permit system, there were 4,685 animals listed and 29,105 plants listed. We fast forward then to 2016. There were 629 animals and 301 plants listed in Appendix 1, and then 4,827 animals and 29,592 plants listed in Appendix 2. This indicates that hundreds of species are added to the CITES appendices, particularly in Appendix 2, every 3 years when the Conference of the Parties meetings are held. In order to monitor the implementation of CITES, a project known as the National Legislation Project was developed. Experts came in and monitored, evaluated the legislation of each of the member countries. These were then put into categories based upon that level of implementation. Category 1 means that the member country has met the requirements required by CITES. 92 members, or just over 50% of the 183. Category 2, implementation does not meet all of the requirements. This is 46 members, 25%. And then Category 3 is where implementation does not meet the requirements. 36 members fall into this category, nearly 20%. A further 8 countries had not yet been assessed, as they had only recently joined the convention. Given this low implementation rate of the member countries, and given the numbers of species traded, the number of species listed in CITES because trade is posing a threat to their survival, and that the number listed, as we saw on the previous slide, keeps increasing, it is vital to make CITES work. Improper regulation of wildlife use, or lack of enforcement, can easily lead to exploitation and unsustainable use. CITES, then, needs to be improved to protect species, the environment, and biodiversity. It also needs to be improved to protect wildlife as a cultural heritage and as an economic benefit. With that in mind, this project laid out 3 aims. We need to know the nature and extent of implementation of and compliance with CITES legislation in all member countries to fully understand the impact of legal and illegal trade on species survival. This will also help to enlighten broader research gaps related to environmental governance in general. The project also identifies lessons in relation to CITES legislation, implementation, and compliance in order to provide evidence to member countries as to how their own practice can be improved, and to inform other multilateral environmental agreements of approaches to implementation and compliance. Finally, I intend to widely share the 3 case studies that are developed from this project of lessons learned with relevant stakeholders and policymakers, not only through this video series, but also through an email to all of the participants and anyone else interested in knowing what the findings of this project were. This is in order to inform changes to CITES legislation, implementation, and compliance, and wider environmental governance. In order to meet the aims of the research, I conducted a mixed methods research project. The first phase of the project, as I mentioned, was a content analysis of the legislation of all the member countries of CITES. Using Legal Atlas database, the CITES website, and Google searches, I found that the legislation related to CITES is available in English for 112 member countries. With my working knowledge of Spanish and Russian, I could actually do the content analysis of a further 20 countries, and then relying on Google Translate, I conducted the content analysis of a further 47 member countries. In 4 of the instances, the text actually could not be translated or was unclear, 3 of these in Arabic and 1 in Somali. Based upon the content analysis, I wrote a Delphi iterative survey. This type of survey is very intensive, very long, and thus usually has a much lower response rate. In the first round, I had 32 government, academic, charity, and other participants. The idea of the Delphi iterative survey is that you then take the findings from the first round and draft further follow-up questions for the second round and send them out again to the same participants or new participants. And in this case, I had 23 participants in the second round. Drawing on the answers I received in that Delphi iterative survey, I identified 3 case studies of best practice. The experts that responded in the survey indicated that Canada, Indonesia, and South Africa had either lessons to be learned or best practice to share. Based upon those 3 countries, I then conducted in-depth interviews with experts in those countries or experts on CITES in general, and that was a total of 18 people that participated. Just to clarify some of the terms that I'm using as I go into explaining in detail the findings from the legislative analysis. Drawing on Mitchell's work and Rosalind Reed's work in 2002 in particular in her book about CITES compliance, I have very distinct definitions of the 3 terms that I'm using. Implementation are measures parties take to make international agreements operate in their domestic law. This might differ to other kinds of implementation or use of the word implementation that we've come across. Compliance, then, is behavior that conforms to a treaty's explicit rules, and I'll describe this in more detail when I give in detail the findings around compliance. And then something that's very tightly related to implementation as compliance is the idea of enforcement of the convention itself in this case. And this, according to Mitchell, is the formal, legally subscribed reaction to a breach of an obligation. So when CITES has been breached, how legally does the member country respond? On to the findings, then, of this legislative content analysis. I've been referring to the National Legislation Project of CITES and how it's ranked into categories, category 1, 2, or 3. And the 4 components of that implementation are that member countries need to have designated 1 management authority and 1 scientific authority. They also need to prohibit trade in specimens in violation of the convention, and that prohibition does not have to be criminal. It can be civil or administrative as well. Prohibitive trade should be penalized, and again, that can be in a variety of ways. That penalty is not set by CITES. And finally, confiscate specimens illegally traded or possessed. There has to be some mechanism where the wildlife is actually taken from the person who is in legal possession or illegally trading it. In terms of the designation of these authorities, MA stands for Management Authority, FA for Scientific Authority, and then I expanded to look at the Enforcement Authority as well to understand that relationship of this 3rd pillar that is critical to CITES. In 41 of the member countries, there is a separate Enforcement, Management, and Scientific Authority. In 17 cases, the 3 are actually all the same. They're located within the same agency. In 85 of the member countries, there is no enforcement authority, which, as you can see from the components of implementation, this is not required, but it's an interesting aspect of how compliance is actually gained if there is no enforcement authority. 58 cases, there's a separate management authority and scientific authority, so they're located in different organizations. In 29, they're the same authority. And then in some cases, in 14, the enforcement authority and the management authority are the same organization. 5 countries do not have a scientific authority at all, which is a failure to implement CITES. And then in 9 cases, we have some overlap. And what I mean by overlap is it's actually the same person that is listed on the country's website as being the contact for the different authorities. And then we see other forms of overlap as well, where you have authorities collaborating together in particular ways. The second component of implementation of CITES is to prohibit trade in specimens in violation of the Convention. From conducting the legislative content analysis, I argue that there is clearly 103 countries that prohibit it within their legislation. However, there are 80 where there is not a clear prohibition of this kind of trade, and that may account for the reason why we see nearly 50% of member countries of CITES not actually meeting the Category 1 standard of having fully implemented the Convention. The third component is to penalize such trade, and again, this isn't prescribed by CITES. This can be done in a variety of ways. The main way that I found in the legislative content analysis that countries penalize illegal trade or possession is either a fine or prison combination, depending usually on the severity or the value of the wildlife. This is the case in 99 instances. For 16 member countries, there are only fines listed within the wildlife legislation related to CITES. 3 of them only listed prison as an option. In 13 of the cases, I felt it was unclear what the penalty would be, or if there was a penalty. And in 52, it was blank, meaning there's no mention of penalty related to wildlife being illegally traded or possessed. Should note, however, though, that is not to say that there is no penalty related to illegal wildlife trade or possession in these countries or violations of CITES. It may well be that they are located in other legislation, possibly in criminal legislation or other administrative or civil legislation, rather than in trade or wildlife legislation, where CITES is usually transposed. The fourth component is around confiscation of illegally traded or possessed wildlife. In 71 of the member countries, wildlife specifically, wildlife only, is mentioned as being able to be confiscated. In 47 of the countries, I found that the legislation indicated not only the wildlife, but that the equipment related to the illegal trade or possession could also be confiscated. In 8 of the countries, only the equipment or tools used for the illegal trade are identified in the legislation. In one case, the use of the wildlife or the equipment involved is only mentioned in the context of it being used as evidence. And finally then, there was one case of specifically that wildlife could not be confiscated, hence the none. And then in 55 of the cases, I was unable to tell from reading the legislation if wildlife could be confiscated if it was illegally traded or possessed or not, which again may account for the almost 50% of countries that have not actually fully implemented CITES. Moving on to compliance then, which, just to remind listeners, is to conform to the treaty's explicit rules. And in the case of CITES, this predominantly has to do with the reporting requirements to the Secretariat, both annually and biannually, but also then efforts to actually implement the convention based upon those 4 components. The Secretariat itself has identified that 18 countries are in need of urgent action in relation to these issues. 31 countries actually have some form of suspensions on their trade, either actively or imminently coming into play, because they have not complied with these explicit rules that are established by CITES. 9 of these are actually the same country. One particular element of compliance that I looked at in more detail was the compliance with the requirement to report every 2 years. And this 2-year report, the biennial report, particularly focuses on implementation and other questions about resources on a standard set of questions that are asked every 2 years. 67 countries have never completed this report. 27 have only completed it once over this 16-year stretch of time. 15 countries, as all member countries, have actually completed it in each of the instances that it has been required. So in terms of compliance, in this particular biennial report, compliance is actually quite poor. That's a summary of the legislative content analysis, and based upon all that information that I've just talked you through, I created the Delphi Iterative Survey, which will be the topic of my next video.